Effect on injunction. The second half of Section 79 is a shield for the authority. It prevents a civil court from staying RERA order. For example, if RERA orders a builder to stop construction because they lack commencement certificate, the builder cannot run to local civil court to get an injunction against the RERA order. The only way to challenge it is through the RERA appellate tribunal. The Real Estate Appellate Tribunal serves as the second tier of the grievance redressal system. It is a specialized judicial body where decisions of RERA authority or the adjudicating officer can be challenged. Section 43 Establishment. The Act mandates a structure, timeline, and jurisdictional flexibility for the tribunal. Mandatory setup. The appropriate government, state or union territory was required to establish the appellate tribunal within 1 year of the act coming into force. Jurisdictional benches. If the volume of appeal is high, the government can establish multiple benches of the tribunal for different regions within the state. Joint tribunals. Two or more states or union territories can agree to establish a single common appellate tribunal to share resources. Interim arrangements. Until a permanent tribunal is formed, the government can designate any existing appellate tribunal functioning under other law to hear RERA appeals. Section 45 Composition of the tribunal. The tribunal is a multi-member body designed to have a mix of judicial expertise and administrative experience. It must consist of the chairperson, the head of the tribunal, members, at least two whole-time members, of which one must be judicial member, one must be technical or administrative member. Section 46 Qualification for appointment. To ensure high-level judicial scrutiny, the qualifications are stringent. Chairperson must be a sitting or retired judge of High Court. Judicial member must have been a judicial officer for at least 15 years or an advocate with at least 20 years of experience in a real estate law. Technical administrative member must have at least 15 to 20 years of experience at a senior level, secretary level in areas like urban development, housing, or administration. Term of office. Section 47. To maintain judicial independence, the terms are fixed. Chairperson 5 years or until the age of 67, whichever is earlier. Members 5 years or until the age of 65, whichever is earlier. No reappointment. Like the RERA authority, members of tribunal are not eligible for reappointment to prevent any bias towards the government or industry. Section 44. The appeal process. Who can appeal? Any aggrieved person. This includes allottees, promoters, or real estate agents. Timeline. The appeal must be filed within 60 days from the date of receiving the order from RERA or the adjudicating officer. The pre-deposit requirement. Section 43(5). This is the most critical hurdle for developers. If a promoter wants to appeal against an order to pay a penalty or refund, they must deposit at least 30% of the penalty amount or the total amount payable to the allottee, including interest and compensation. Note, without this deposit, the tribunal will not even hear the appeal. Powers of tribunal. Section 53. The tribunal is not bound by the strict rules of Code of Civil Procedure or the Indian Evidence Act. Instead, natural justice, it is guided by principle of natural justice and can regulate its own procedure. Civil court powers. It has the power to summon witness, require document production, and receive evidence on the affidavits. Enforcement. Its orders are enforceable as a decree of civil court. Under the Rera Act 2016, the Appellate Tribunal acts as the secondary judicial tier. The section between 43 and 54 establish a fast-track legal process designed to prevent the long delays typical of civil litigation while ensuring a fair hearing for all parties. Application to the tribunal. Section 44. Any person aggrieved by a direction or order made by the authority or an adjudicating officer can file an appeal. Timeline. The appeal must be filed within 60 days from the date on which the copy of order is received. The tribunal may entertain an appeal after 60 days only if it is satisfied there was sufficient cause for the delay. The pre-deposit rule, section 43(5). This is the most critical hurdle for promoters. If a promoter files an appeal, it will not be entertained unless they first deposit with the tribunal at least 30% of the penalty amount or the total amount to be paid to the allottee, including interest and compensation, or both as directed by the tribunal. Resolution target, the tribunal must endeavor to deposit or appeal within 60 days of filing. If it cannot, it must record the reason for delay in writing. Section 53, powers of tribunal. The tribunal is designed to be more flexible than a traditional court. It is not bound by strict technicalities of the Code of Civil Procedure or the Indian Evidence Act, but it is guided by the principle of natural justice. Procedure, the tribunal has the power to regulate its own procedure. Civil code powers, for the purpose of discharging its function, it has the same powers as a civil code in several areas: summoning and enforcing the attendance of any person and examining them on oath, requiring the discovery and production of documents, receiving evidence on affidavits, issuing commissions for the examination of witnesses or documents, reviving its own decision and dismissing an application for default. Section 54, execution of orders. Once the tribunal passes an order, it must be followed. The Act provides specific mechanism to ensure decrees are not ignored. Enforceable as a decree. Every order made by the appellate tribunal is enforceable in the same manner as a decree of civil court. Transmission for execution. The tribunal can send its order to a local civil court having jurisdiction over the area where the project is located. That court will then execute the order as if there were its own decree. Recovery of arrears, section 40. If an order involves the payment of money, refund, interest or compensation, and the party fails to pay, the amount can be recovered as arrears of land revenue. This allows the government to attach and sell the property of the defaulter to recover the funds. Section 58, the final recourse. While the tribunal decision on facts is generally final, any person aggrieved by a decision of appellate tribunal may file an appeal to High Court within 60 days. However, this appeal can only be made on sustainable question of law, meaning you cannot argue about the facts of the case again, only how the law was interpreted. Section 58 of the Rera Act 2016 acts as the final legal safety net, allowing parties to challenge the decision of the appellate tribunal. However, unlike the first appeal, which can be on facts, this second appeal is strictly limited to legal interpretation. Section 58(1), right to appeal. Any person aggrieved by the order or decision of appellate tribunal may file an appeal to the High Court. The limitation period, the appeal must be filed within 60 days from the date of decision or order was communicated to the person. Jurisdiction, the appeal must be filed in the High Court or state or union territory where the real estate project is situated. The substantial question of law rule, this is most critical constraint. You cannot approach High Court just because you are unhappy with the facts. Example, the builder didn't finish the pool. You can only appeal if the case involves a substantial question of law as specified in section 100 of the Code of Civil Procedure. What is substantive question of law? Substantial question of law. It is an issue whether the law is unclear, has been misapplied, or where the tribunal decision is perverse, completely unsupported by evidence. If the dispute is merely about he said, she said regarding facts, the High Court will generally refuse to hear it. Section 58.2, consent orders. The Act explicitly states that no appeal shall lie against any decision or order made by the appellate tribunal with the consent of the parties. If both the builder and the buyer agreed to a settlement of a compromise before the tribunal, they waive their right to challenge that specific order in High Court. Powers of the High Court. In Rera appeal, the High Court role is to act as the corrective authority for legal errors. Formulating the question, the court must satisfy itself that the substantial question of law exists and then formulate that specific question for the hearing. Confirmation or reversal, it can confirm, set aside or modify the tribunal order based on its legal analysis. Condonation of delay. While the 60-day limit is strict, the court has the power to accept a late appeal if the person shows sufficient cause for the delay. The Real Estate Regulation and Development Act 2016, Section 59 to 68, establishes a robust penal framework. It transactions the sector from a free for all to regulate environment by imposing heavy financial penalties and imprisonment for non-compliance. Penalties for promoters. Promoters face the strict penalties as they hold the primary responsibility for project delivery and financial discipline. Under Section 59, Subclause 1, failure to register project. Section 3, penalty up to 10% of the estimated project cost. Section 59, Subclause 2, continued non-registration after initial order, imprisonment up to 3 years or further, fine up to 10% or both. Under Section 60, providing false information. Under Section 4, penalty up to 5% of the estimated project cost. Under Section 61, violation of any other provision of Act, penalty up to 5% of the estimated project cost. Section 63, failure to comply with authority orders, daily penalty up to 5% of the estimated project cost. Section 64, failure to comply with tribunal orders, imprisonment up to 3 years or fine up to 10% or both. Penalties for real estate agents. Agents are penalized to ensure that only deal in registered projects and provide accurate information to buyers. Section 62, non-registration or violation of Section 9 and 10, 10,000 per day capped at 5% of the property cost. Under Section 65, failure to comply with authority orders, daily penalty up to 5% of the property cost. Section 66, failure to comply with tribunal orders, imprisonment up to 1 year or fine up to 10% or both. Penalties for allottees buyers. RERA is not just a builder bashing law, it holds builder accountable for their contractual duties. Under Section 67, failure to comply with authority orders, daily penalty up to 5% of the property cost. Section 68, failure to comply with tribunal orders, imprisonment up to 1 year or fine up to 10% or both. Important legal nuisance, compounding of offense. Section 70, if an offense is punishable by imprisonment, the court may compound the offense, allow the offender to pay a fine instead of going to jail. However, this is at the discretion of court and usually limited to first time or minor offenders. Section 69, liability of companies. If an offense is committed by the company or firm, every person who was in charge of the business at the time, directors, partners, managers, is deemed guilty unless they can prove the offense happened without their knowledge. Calculation base. Most penalties are calculated based on the estimated cost of the real estate project, which includes both land cost and construction cost. For individuals, it is based on the specific cost of the plot apartment. While the RERA authority handles registration and general regulation, the adjudication officer is the specialist judicial hand of the Act, specifically empowered to determine the quantum of money a victim should receive. Section 70 and 72 defines how these damages are calculated and who has the power to award them. Section 71, power to adjudicate. The authority, in consultation with the government, appoints one or more judicial officer who must be or have been a district judge to act as a adjudicating officers. Exclusive jurisdiction. The AO has the exclusive power to adjust compensation under Section 12, 14, 18 and 19. Note, while the RERA authority can order a refund, the AO is the one who decides on compensation for things like mental agony or actual financial loss. The consumer court opinion. If a buyer had case pending in the consumer forum before RERA started, they have the option to withdraw that case and file it before the AO to get a faster resolution. Speed of justice. The AO is required to dispose of the application within 60 days. If delayed, they must record the reasons in writing. Summary inquiry. The AO conducts a summary inquiry, meaning they don't get bogged down in long-winded trial procedures but still follow the principle of natural justice, giving both sides a fair chance to speak. Section 72. Factors for determining compensation. How does the AO decide whether to award 10,000 or 10 lakh? Section 72 provides the formula. By listing the factors the officer must consider. Unfair advantage. The amount of disproportionate gain or unadvantage made by the promoter as a rule of the default if quantifiable. Amount of loss. The actual amount of financial loss caused to the allottee due to the builder's default. Repetitive nature. Whether the promoter is a repetitive offender. If the developer has a history of same default, the compensation can be higher as deterrent. Justice and equity. Any other factor that AO considers necessary in the interest of justice. Authority versus adjudicating officer. It is a common point of confusion. Whom should you approach? A 2021 Supreme Court ruling, New Tech Promoters versus State of UP, clarified the role. Refund of the principal amount, Rera Authority. Interest on the refund, Rera Authority. Interest for delay without withdrawal, Rera Authority. Compensation for loss and agony, adjudicating officer. Compensation for defects, adjudicating officers. Section 71, subclause 3, power of adjudicating officer. To ensure through inquiry, the AO is vested with the power of civil court. Summoning, they can force any person to appear and give evidence. Document production, they can order the builder to produce hidden accounts or internal documents. Evidence on oath. Testimony given before the AO is legally binding. The bottom line for buyers, if you simply want your money back with interest because the project is late, go to the authority. If the delay has caused you specific additional loss like extra rent paid or business loss, and you want to damages over and above the interest, you must file before the adjudicating officer. That was all for this video. See you next video. Till then, please like, share and subscribe. Thank you.